Hi, everyone. Good afternoon. Carl Steinbeck here. Sunday afternoon. I was planning on jumping on tonight as well. I was planning on being on last night, but as you know from my post, my sister, older sister, had a medical situation that came up and just had no interest in live streaming because my sister is having some kind of predicament health wise. So, anyway, things are stabilized, thankfully, and I really appreciate and she appreciates. And Leslie and the family appreciate all your well wishes. I can't believe you guys actually type things of support and even hearted stuff. So that's very kind and sweet of y'all. And like I said, it means a lot. And so, what I wanted to do is because Leslie's going to be on work duties for the rest of the night, I figured that I would try to cover up as much as I cover up as much of this case as I can in this short condensed frame. So I plan on doing probably a 2 hour live stream here followed by a break and then maybe getting on another 2 hours. So it's going to be sort of a marathon run here if all goes well. But what I'm going to jump into now is day one, some of the key takeaways, key witness testimony from day one. And what I'm looking for in a murder case, the first responders, when you have the defendant right there with the first responders, being able to somewhat observe while they're frantically trying to save the life of the victim, the demeanor and behavior and character and all that of the accused right there is a very telling thing that I'm looking for to indicate guilt or innocence. And so I'm looking for clues as to, is this guy acting like he's wanting the person saved, or is he acting like, it's not a big deal to them, or are they just faking it and trying to act like they're concerned? So anything in between, you got the full gamut of things. So just try to come into it with an open mind. And so let me go ahead and we're going to go to one of the EMT for persons that responded. This from Court TV. Let me expand that.
Good morning, Ms. Baldwin. Could you please state and spell your name for the court reporter?
Marisol Baldwin. It's Marisol Baldwin.
And Ms. Baldwin, where are you employed?
National Fire Department.
How long have you been with NFD?
9 years and 8 months.
How are you currently
We can skip
They're not responsible for any.
working on the 25th?
I was working as an advanced EMP.
And on the 25th, did you respond to an incident located at 1522 Lebanon Pike, apartment 107?
Yes.
And is that here in Davidson County?
Yes.
Do you recall what type of incident you were initially responding to?
I believe our CAD system said allergic reaction.
And were you in the ambulance
Yes.
as the driver or the passenger?
Driver.
And did you respond to that apartment with lights and sirens?
Yes.
Why?
That's our policy. Every call gets lights and sirens.
And do you recall what you initially witnessed when you arrived at the apartment complex?
As we arrived, we were led into the apartment and we found our patient lying in one of the bedrooms in the apartment. She was lying face down on a comforter.
Okay, do you recall who led you to the apartment?
Yes.
Okay, right there. She's 5 months pregnant and she's lying face down. That automatically is sending up warning flags for me. It's like, wait a minute. Why would you allow somebody be on their back like that? Aren't you giving them mouth to mouth? Aren't you trying to like have some kind of eye contact, face contact with them? You let them being face down on in a thick comforter. That makes no sense to me.
What is that?
You're pointing at someone.
Yes, I'm sorry.
Did you see a male that day?
Yes.
On the 25th? Okay.
Yes.
Did you see him in the courtroom?
Yes.
Can you point him out, describe something he's wearing?
Blue suit with white shirt.
She's identifying the defendant.
Your Honor,
Good
correct to
time.
reflect her identification of Mr. Taylor.
Okay.
Your Honor, if I could pass 2 photos. please. Ms. Baldwin, do you recognize those photos?
Yes.
Your Honor, if I could publish the first photo, we have them on a PowerPoint, so it'll be digital.
Okay. Go there.
Ms. Baldwin, what are we looking at?
This is the apartment. As you go in the front door, this is what we saw.
Okay, and the two females standing on the left, were they
Go there.
Having
Why?
the jury? What you mean by that?
And we, our questions that we were asking.
What were you asking?
If she was allergic to anything, because it did come in as an allergic reaction. And all he was saying was she ate bad food.
She ate bad food, really?
Was he able to give you any other information about, generally about who she was and her health history?
Not that I recall.
Okay. And when you got into the apartment, was that scene considered safe?
Initially, yes, but we didn't really have our firefighters there yet. And with uncooperative family or bystanders, we deemed it unsafe.
Okay, what do you mean by uncooperative family members?
The male there was kind of getting in our working space and we couldn't properly assess and treat the patient.
Okay, what do you mean by that he was getting in your working space?
He wasn't letting us do our job. He was in our face, just trying, I don't know what he was trying to do, but we were trying to get her on our stretcher and wasn't following the commands that we were asking him.
And what commands were you asking him?
We usually don't want family in our working space. So we were probably telling him to step aside.
And where did you find the patient?
We found her in the bedroom to the right of this kitchen. She was on the bed. It looked like a comforter that she was on, and she was face down.
And is that the second photo that you have?
Yes.
And is that what we're looking at right here?
Yes.
So while she's on the bed, she's going to go on to say she's at the end of the bed facing sideways. And so he's interfering, getting in their face, and they basically don't deem it a safe situation with him there. I mean, that's really bizarre. And I think it's something that is definitely raising some red flags there for the jury.
And can you describe to the jury how she was laying on the bed?
She was laying horizontal, so not how you would typically sleep where the pillows are. She was towards the end of the bed, and she was on her face down.
And what about breathing? If you're face down, how are you able to breathe? So if you're already being choked out with some bad food or something, I mean, that's sort of like the last thing you want to do is be face down. On the flip side of it, of course, if you're on your back, you can be choking worse because the obstruction, if there's an obstruction, for example, can't come out. But just her on her face down like that's just so bizarre.
And at some point, did you roll Ms. Benning over?
Yes.
Okay, and can you describe to the jury what you saw when you rolled Ms. Benning over?
We rolled her over, and we immediately noticed that she was unresponsive. She didn't respond to us flipping her over on her back. And we noticed that she had some kind of fluid around her mouth.
Okay. Was that fluid any particular color? Do you recall?
It was like a light pink in color.
We've already kind of touched on this, but based on your experience, did it appear Ms. Benning was suffering from an allergic reaction?
Not fully. That wasn't. We were definitely trying to cross off multiple things that it could be, but it wasn't a typical response that we would see for an allergic reaction.
Was Ms. Benning limp?
Yes.
And did Ms. Benning have a pulse?
At what time?
When you got to her.
I don't personally remember checking it.
Would that have been something that the medic did?
Yes.
And at any point, did the male in the apartment try to touch Ms. Benning?
Yes.
Okay, can you describe to the jury what happened?
So our firefighters were pulling their truck into the parking lot. So they were a little bit behind us, but we couldn't physically carry her, my partner and I. And he took it upon himself to do it. And we don't allow help from outside agency, like from our people. And he attempted to do that. So that's what I meant, that he wasn't listening to our commands. And then he eventually placed.
Does that sound like a consciousness of guilt type behavior? Like he's trying to show that he's so involved, he's actually trying to help it because he wouldn't have done anything to cause this, right? Or is he freaking out because he has gone too far? He was just trying to have the baby aborted without the mother's knowledge. And so this thing's sort of spiraling out of control, that he's now worried that this is going to be a double homicide kind of situation.
Her floor right in front of the island.
Back to the other side.
Mm-hmm.
Okay, can you kind of describe to the jury where he put this
So right in front of the island, just in that empty space, that's where he put her. And then when our firefighters got there, then we all lifted her and put her on our stretcher.
Okay, and then what did you do with Miss Benning?
We wheeled her to the ambulance.
At any point, do you recall someone else showing up?
Yes, a young lady.
And what do you recall about that young lady's demeanor?
She was hysterical. She was crying, asking us questions, trying to get inside the ambulance, looking in the windows.
Yeah, see, that's the demeanor you're hearing of a friend, and yet this guy's daughter in the womb is maybe not going to make it here because the mom's not going to make it, and he's trying to do what? Interfere with them? Is he upset? Is he crying? We don't hear any of that. None of that stands out to this emergency personnel here.
And was this much different than the male's demeanor?
Yes.
Okay, how so?
She was crying. She kept asking us, is she going to be okay? Is she going to be okay? What's going on?
Yeah, okay, so contrast that with we're not hearing anything about Blaise Taylor asking about, hey, is she going to make it? Is the baby going to make it? Is he not saying, hey, you got to save the baby too? Come on, hurry. You got to save these folks of mine.
At any point, did you see Mr. Taylor crying?
Not that I saw.
At any point, did Mr. Taylor ask you if she was going to be okay?
Not that I can remember.
And once you got Miss Benning into the ambulance, what happened after that?
So she was put on the cardiac monitor. She had pads put on her. She had no pulse. We were doing compressions. We were doing a procedure where we stick an airway and breathe for her, starting IVs, giving epi, lots of things simultaneously happening.
And at what point did you transport Miss Benning?
Once my
Now, the prosecutor should be asking about, was there anything mentioned about a baby? So she doesn't bring that up here, and I think that's a critical point that they omitted, but I think otherwise the jury still gets the gist of it.
partner, she said she was ready, and we took firefighters with us, and then I think it was after 10 minutes of being there total time.
And did Mr. Taylor ever attempt to get in the ambulance with Miss Benning?
Not that I recall.
And where did you take Miss Benning?
Vanderbilt Adult ER.
And did you transport Miss Benning with lights and sirens?
Yes,
Okay, and why so?
she was critical.
What do you mean by that?
Cardiac arrest is deemed critical.
And at any point, did Miss Benning ever have a pulse?
Not that I can remember with us.
Can you imagine no pulse? No pulse. Your odds of making it when the EMT crew shows up and you have no pulse, it's highly unlikely you're going to survive that. Now, they do get a pulse later, but it's very much a dire situation here.
And once you got to Vanderbilt with Miss Benning, is that when you released care and that's when Vanderbilt took over?
Yes.
Got it. Give me 1 minute.
Okay.
Yeah.
Okay, what's your last?
It's Rose now. I believe it was Arwen at the time. I'm sorry, Agral at the time.
Guess what other EMT was there?
Yeah, at this time, we would like to amend both photos as an exhibit.
1A and 1B, please, and I'll pass it to this.
If at any time you don't understand, please let me know and
Okay, this is Ed Jointer. He is a partner at the law firm there, Quionis and Associates, out of the Houston area. So he hired out-of-state counsel, most likely because of connections through his dad, who was a football coach at the Texas A&M University, which is probably like 90 minutes away from Houston. So they're paying a lot of money. They're probably, I guess, estimate probably anywhere from $700 to $1 million for this defense.
I'm trying to rephrase. I want to just make sure I understood your role on that day. You were acting in what capacity?
I was an EMT at the time.
And one of the duties you described for EMT basic was
Just
basic life-saving measures, you said?
Correct.
And to be clear, you were the driver that day.
Correct.
And so when you arrived there, you said you were led into the apartment.
Yes.
Who was you led by?
Male that was on scene.
Mr. Taylor?
Yes.
So he helped you all find the apartment.
I believe when we saw the hallway, he like popped out of the apartment, but I can't exactly recall if he led us but he was there and said, this is the apartment.
Is there a reason why you said he led us if you didn't feel he led you?
He showed us the apartment,
And that's assisting, correct?
telling us where the apartment is.
Okay. And once you got into the apartment, 1 second, y'all, can I see State Exhibit 1 and 2? Okay. 1A and 1B, I'm sorry.
all right.
Commissioner
So,
Butler-Shaw? Okay.
I mean, he's not dumb enough to obstruct them coming into the place, and him trying to get them there and call 911. I mean, you don't know where this apartment is. It would be on your phone. If you didn't know it by heart, you could easily look it up electronically on your phone. So was this to buy time? We get into that later. You'll hear the 911 call. I think I'll jump ahead. He doesn't really score any points here. He's just trying to bring up the fact that he's somewhat helpful and his demeanor and whatnot. It's just nothing to highlight that he was really frantic and trying to make sure that they're doing anything they can do to save the mother and expecting child. So let's go ahead to the next witness. This is Andrea Browning. She's Jade's stepmom since 2009. She went to OBGYN clinic with her, and she talked about how Jade was looking forward to being a mom and whatnot. Let's just watch a few minutes here. She was with her when the sonogram showed she was having a girl.
Good morning, Ms. Browning. Could you please state your name for the record?
Andrea Browning,
And could you spell your first name and your last name for the court reporter?
ANDREABR.
She also knows the girlfriend, Najaya, and she says that she would have no, from her experience knowing her, she's friends with Jade since they were 6 years old or sixth grade. I forget which it is, but she has no suspicions of any involvement of any wrongdoing by Ms. Jackson.
OWNING.
And Ms. Browning, what was your relationship with Jade Benny?
I was her stepmother by his mom.
When did you become Jade's stepmom?
When I married her father in 2009,
And how old would Jade have been at that time?
11.
And you met her before you actually married her father?
Yes,
And it's her father, Dennis Browning.
correct.
Where were you living at the time that you met Jade and you and her father got married?
We were living in Fort Walton Beach, Florida.
And did you continue to live there, or at some point did you move?
We moved in 2016 or 15, something like that.
So I'm going to go ahead. You get a sense of that witness there. Let's go ahead and jump to Allison Mulale. She's the OBGYN that Jade Benning was seeing. And that is this person right here. She helped establish when around the time frame that she was expecting to have the delivery. There was some question about what she asked Jade about whether she was on any medications. Jade said she was on any medications. And using, they didn't do any tests for drugs. So let's go to some of the cross-examination here, because I think this is really telling here and very strange. Start here.
Be outside the scope of witnesses' knowledge,
May I respond?
and whether it's surprising or not is relevant.
What's your response?
Yes, there's just been a,
Let me back up.
Was she doing all the right things to become a mother?
Yes.
Those are my questions.
Let's sound up, Max.
like to just have one moment.
Right, so here's the defense attorney. She's sort of scrambling before she gets up there. It's like she wasn't ready. Bringing her phone and a laptop and the notebook. That's a lot to bring up.
Dr. Mullally, how are you?
Good, how are you?
She's looking pretty
I am
nervous.
good, thank you. I am Letitia Quinones Hollins. Can I ask you a few questions? At any time you don't understand, let me know. I do my best to rephrase.
Okay.
Just a few questions for you, Dr. Mullally. Will you tell me, am I saying that right?
Mullally.
Mullally. Dr. Mullally, can you tell me, have you been able to determine when Ms. Benning would have become pregnant based on your examination of her?
Well, by her dates, she would have conceived roughly 2 weeks after her first day of her last period.
Okay. And the first day of her last period was what?
I don't remember that. I have to look.
Will you trust me if I tell you that I just looked in the records that you just reviewed and we got into evidence? If that date was, patient's last menstrual period was September 12th, 2022?
Yes,
Do you see that there on page 1 of 8?
yes,
And so then you would tell me then that her date of conception would have been 2 weeks after that?
yes,
And that would put September has 30 days in it, does it not?
yes,
And if we put 14 days past that, that puts us at September 26th. Is that right?
yes.
So then we would be safe to say that by September 26th of 22, Ms. Benning would have been pregnant.
Roughly, yes.
And what day was she in your office?
November 16th.
And that is the day that she was diagnosed, if that's the proper term, of being pregnant.
Well, it was confirmed to be an intrauterine pregnancy.
Okay, confirmed to be pregnant. Fair enough. So would it then be safe to say that if September was the last time she had a period, she did not have a period then in October?
Correct.
Now, you stated on direct examination that the patient did not or was not involved in any drugs, to your knowledge. Is that right?
Correct.
Now, to be fair, you did not test her for drugs, did you?
No.
So you're only going off of what she shared with you. Is that right?
Yes, and somewhat by her vital signs and her demeanor.
But you'll agree with me that certainly someone's vital signs and demeanor is not indicative as to whether or not they're using drugs.
Not always correct.
Would it be surprising to know that Ms. Benning had sent a message to Ms. Nigella Jackson that she was doing so much Adderall and
I
alcohol?
object to the hearsay that's outside the scope of the witness's knowledge.
May I respond?
And whether it's surprising or not is wrong.
What's your response?
Yes, there's just been an allegation that Ms. Benning has not done any drugs in her
Said
life.
to her knowledge. Now, they're objecting to hearsay.
It's in regards to
So
impeachment.
you want to ask if she had any information about that?
Dr. McLeod, did you know that, or would you have known that Ms. Benning had felt that she was doing so much alcohol and Adderall that it was
All right, I'll
causing?
sustain the objection.
Can I give you a hypothetical?
Yes.
Okay, so the defense attorney is trying to establish that the victim, Jade, was using drugs, illicit drugs, prescription or otherwise abusing drugs. And so therefore the defense theory is the most likely cause of her death is her using these drugs of cocaine, and she overdosed on it. It's a cocaine overdose. That's basically their defense. And so any other drug usage she has makes it more likely that she would have used cocaine, right? Because if you're using a bunch of other recreational drugs, you're more likely to use cocaine as well, either accidentally or intentionally, as opposed to somebody else slipping you a Mickey, as they used to say, where somebody's spiking your drink or your food. So here, I think there's a constitutional right to present a defense, which is that Jade has had other past history with bad drugs, and therefore that's something they want to argue, that this is a intentional or accidental overdose, and it has nothing to do with the defendant. So the defendant has no history of drug usage, but she does, and that's something they should be highlighting. So what we have here, though, is a questioning of some message, some text message that the defense attorney is saying that Jade sent to her friend, Ms. Jackson, Nigella Jackson. So let's see what happens here.
If a patient,
Jack, this witness has not been considered as an
Hypothetical
expert.
about what?
about a patient doing drugs or alcohol.
You want to ask this doctor if they want their patient using alcohol or Adderall while they're pregnant?
No, I don't. What I would like to do,
What's your question?
what I would like to
What's
do,
your question?
my question is whether or not, based on this doctor's statement, that Ms. Benning was not doing drugs and nor alcohol, and that she would be able to tell by her vital signs.
Is that your question you're wanting to ask this lady?
The question I would like to ask her is whether or not someone feeling as though they're doing so much Adderall and alcohol, their body is shutting
She
down.
doesn't have any knowledge about that. And I'm sustaining the hearsay objection.
So am I not allowed to ask
I
this?
sustain the hearsay objection about your question.
Let me ask you in another way, if I may. Did Ms. Benning ever share with you that she was doing Adderall?
No,
Did she ever share with you that in November she was doing mushrooms?
no,
Did she ever share with you that she was doing alcohol?
no,
Did she ever share with you as her medical professional that she felt like she was doing so much Adderall and alcohol that her body was shutting down?
no,
Okay, so using so much alcohol and Adderall, which is a stimulant, that her body was shutting down. Okay, that's like the most damaging information that the defense is trying to bring out to make it look like she's whacked out on drugs, even though she's pregnant. I mean, that's pretty damning exculpatory type information, I would say. If you're a prosecutor, you don't want to hear that of your victim. And so let's see where this goes. It gets pretty crazy.
If she would have shared that with you, would that change your previous statement in regards to that she was not doing any drugs?
If she told you she was using drugs, that would change your opinion about whether she was using drugs, is what she's asking.
yes,
Okay.
Fair enough, thank you. But what you've just represented to this jury, is it not, Dr. McClellan, was that based on your knowledge and representations to you by Ms. Bennings, she was not doing any drugs or alcohol at all, is that correct?
correct.
Thank you.
Okay.
Any other?
So think about this context again. To ask a question on cross-examination of a witness, the attorney, any attorney in court, you have to have good faith basis to ask a question. So any drug usage question she's posing to this doctor, she has to have a good faith basis. In other words, there's something in either in the prosecution file or something she knows from her. It could be just from one person, your client, Blaise Taylor, something that Blaise could tell you that nobody else knows on the government side, but something that Blaise tells you. So those kind of questions are relevant to try to establish your theory that it wasn't Blake that gave her the drugs. She took the drugs on her own, and whether it's intentional or accidental overdose, it has nothing to do with the defendant. So, but here's the thing. You have to have a good faith basis for doing that. And so you just can't make stuff up. You can't, for example, you can't have a defense attorney saying, well, are you aware she used cocaine the night before? Are you aware that she used heroin the day before that? Are you aware she was, on LSD the third day before she died? You can't just make up stuff. You have to have a good faith basis for doing that. So keep that in mind here when these next minutes play out.
Any redirect?
No, Your Honor.
Okay.
May this witness be excused?
Sure. You get here. Thank you.
Thank you, Your Honor.
Yeah, I think I'll cover some of that later. The Karen Reed case, civil case.
All right, ladies and gentlemen, we're going to break for lunch. Just remember what I said about not discussing the case, forming any opinion about it, the other admonitions I gave you yesterday. We'll get back here in 1 hour. Step down.
Okay, so lo and behold, everybody's going on a 1 hour lunch break. He's looking worried. He's got a worried look on his face. He should be worried from the evidence I've seen so far. I haven't seen all of it. I haven't seen most of it yet. Okay, so right now, Country's thinking she's okay. She got away with something. Witnesses departing the courthouse, Dr. Malloy, and they're able to bring out this information that Jade was basically on so much alcohol and Adderall that she basically fallen down, can't even function. Is that the truth? Okay, now let's jump ahead. let's jump ahead an hour and see what starts up after lunch here. The prosecution, you'll see here in a minute, should have addressed this right away. Okay, here we go. You haven't turned the sound on.
Mr. Honor, I would like to address something that came up during Ms. Holland's cross-examination of Dr. Mullally. She specifically asked her about a text message that Jade might have sent to Nigella Jackson about
Body
doing
shaking, yeah, or
Adderall and alcohol. The text message that she's referring to is not a text message that Jade Benning sent. It is a text message that Nigella Jackson sent Jade Benning in November of 2022. The state's position is it is not in any way relevant to Ms. Jackson's credibility as a witness or her ability to remember the events of February 25th of 2023.
I haven't gotten anything to Ms. Jackson yet, but
Yes, but the state is asking that the defense not be allowed to ask witnesses about messages unless they have shown them to the state. She misstated the message and who the sender was, and that was inappropriate and wrong, and we would ask that she provide us with a copy of anything she's asking.
May I respond?
do you think the message that you quoted the doctor is from Ms. Benning?
I am looking at
That is
the,
just a yes or no.
yes, I am. Yes, I
Oh, she's holding up papers like a defense. Oh, okay, I'm looking at.
am, based on
She
the records
doesn't
that I have.
She thinks it's from Ms. Benning.
And that is why I'm asking the court that she be required to provide us with a copy of it so that we can
Is it
determine
not
that.
something
before
you
she-
already have?
I
Where
have
do you
a
record?
copy of the message.
Let me
right
see.
I mean, the prosecution should right away be able to establish she's misstating the record we gave. I mean, the information that the defense counsel is holding up came from the prosecution office, so they should have the exact same page. So her saying you should have to show us what you're going to ask them about in cross-examination. I mean, you're the one that gave them that information, prosecutor. So why aren't you calling it out by page number and line number? Exactly what was misquoted, missourced.
Let me make sure I give you the right one. And what I was trying to tell the court was that this is the dump of Ms. Benning's phone. So I am referencing the dump that we were provided by the
So
state.
still gotta know who it's coming
Yep,
from.
so let me find it,
Okay.
and then I will turn it to the court. Because what I saw on there was, it was from Ms.
What I saw was, so right now she's already like backpedaling. It's like, from what I saw, okay, this should be rock solid. This is like a huge point for the defense to make. And you got 3 attorneys here that have helped prep this. And this is like a very exculpatory, very much a dagger in the prosecution's case, that she's like so out of it. She's almost like collapsing. She's on so much abuse of alcohol and prescription meds.
Benning. So if I'm wrong, it's based on the records that we received from the state. So I'll find it and I'll get it to the court.
Okay, let me see it.
Okay, you come.
So
Who's the next witness?
Counsel Jones.
So you're using a quote that you extract off a document, but you can't pull the document very readily there in quick fashion.
Keon. Okay.
Look at none of her co-counsel look like they're trying to help rescue her. He's on his phone. Joyner's on his phone. Why wouldn't it be on your laptop or a hard copy?
Does the state have their available text that you're saying came from Ms. Jackson to Ms. Benning about her body shaking?
That's,
Is that what you're referencing, Ms. Hollins?
no, it was not about body shape.
Well, that's what you asked.
No, what I asked was,
Look at that message and see if that's what you're speaking of.
yes, that is. That's it. So it was
Okay.
on my computer, so
Let me
let me
see
pull
it.
it up on my computer.
Well, that's the state's copy, just let me see it.
But that's the same copy, it's not what I was looking at.
But that's the text that you're referencing.
I don't know that that's the text.
I thought you said it just was.
The text context was, it doesn't mean that the sender and the recipient that I was looking at was, because I verified that before I.
That I was looking at. So she's already looking like she knows she messed up, that she's getting called out on it.
Into it. So if I can pull it up on my computer, because I just remembered I was looking at it from my computer.
Well, it says a phone number ending in 0608. How do you pronounce it?
Okay, Dreamscape, you're saying that prosecution could not give the defense aid in time to what defense aid because it didn't exist. Letitia read it wrong. No, the document did exist. It did exist, and they should be able to know exactly what was said and when you're talking about falling down. You're having to do with alcohol and the Adderall, because they know this is impeachment evidence that can be used against Ms. Jackson. So they should right away go, wait a minute, they're mixing that up. They're mixing this. You should be that on top of stuff as an attorney, okay? Both the prosecution and the defense. It's just very much flat-footed advocacy here. And what is the defense attorney doing? She's trying to she's like wiping out on the ice here with her skates. She's doing the back pedal and well, you know. So
Nausea. My body is starting to feel like it's shutting down.
Yeah, it's not shaking, you said shaking.
You said it was from Ms. Benning. That's what I'm trying to determine.
I'm trying to pull it up for you
Okay.
so that I can get it to you.
So they both happen to say the same thing? Really? I don't think so. The judge is like, yeah, there is not a document that shows that this is a conversation from Jade, but there's a text history between the two of them, and that's what they're going by. And the document right there that the judge has shows that it came from Letitia to Jade, not the other way around. So it's the same document. They're just misquoting the author of it. That's what I believe. I believe it's the same document. Because think about whether you have a printout of all of Jade's text messages or a printout of all of Letitia's, it's all going to show who it's sent or who's receiving, whatever.
11:29:48 seconds.
Yep, I gotta get on the internet.
Sure, he's not present. They came back from lunch, and this was raised by the prosecution. By the call. Watch this as a defense attorney. It's is this some kind of trickery or something? The jury's gonna be looking at this once the truth comes out, and they're going, okay. At a minimum, defense counsel are not well prepped on this case. Why is that? Defendant there, he's looking sort of like, you know what you're doing? Sort of looks like a skull text here.
If you look at the bottom of page 169, it has the sender's number, and then it has the message next to, the message is the next one. Look at the bottom of the page.
Oh, so this should exonerate you then.
Okay, I'm just trying to, I don't know, show that to this thing.
If you look at the bottom of that page, the sender number is 501. The recipient is Nigeria. The very next message is that message that we quoted.
Her copy is the metadata.
Yeah, no, I get it. I can read all of this. On page 1969, the record 4388, it says the sender name is Nigeria, 501, 541, and this following page, 1970, is the message.
If you also see the
The sender goes with this message.
Can I finish? Dr. Tobey?
Let me ask you a
The
question.
sender says 501-541-5008.
Is there a police officer here that can tell us who's the sender and who's the receiver on that?
I absolutely can get someone here.
Okay, why don't you do that?
It'd be so evident, even if the name wasn't in front of each message, that text message that's sent. It's obvious who's who in the messaging history. So very, very shoddy lawyering here.
So you're, Ms. Hollins, you're still thinking that this message is from
What I'm sharing is when I looked at the sender's number, it said 501. And then when it said recipient, it did not say Jay Benny. So when I saw sender 501,
Okay,
which is,
well, let me ask you, are you acknowledging you're now mistaken?
I don't know that. I can say that she's right because it does say sender's name, Nigeria, but the number was 501-541-0608.
So you're going by a number that you think you can remember that is traced to Jade versus the name of Najasha on the actual document as being the one sending the text. This is
What do you need to figure out whether you were mistaken?
Let me just speak with my staff who sent it to.
Okay.
so your staff is going to know something that you're cross-examining this doctor on, not you. You're in command as the lead attorney. Thanks, Granny Debbie. Look at all this time. You have to have a good faith basis to ask a question, as I said earlier. And now there's this hubbub going on about
So what she shared with me that it wasn't that from Nigeria. However, we have several other messages where she does in fact do the same drug. So we can.
Okay, so they talk about drugs, not conversations, but she's not talking about this really scathing point about she's fallen down. She's so overwhelmed with this alcohol combo with Adderall.
You're jumping way ahead of me. The question you asked the doctor.
She's trying to like make an excuse, and well, there's other information. So this one is incorrect. She's conceding she was incorrect.
Is that wrong?
Let me say this.
That's just a yes or no.
Well, no, it's not, Your Honor. If I can go the
Oh man, you're sassing the judge right now. That's not a good look as an attorney. Talking back to a judge like that, and
record, please allow me to say what I need to say.
Sure, for the record. Go ahead.
Thank you.
it just doesn't sound good. Her demeanor towards the judge does not show respect. The due respect I think that is owed to the court.
We were mistaken in regards to that
Does
particular.
the jury need to know that?
They can't,
Okay, now he cut her off at this point, but judges can do that.
but if they know that, then I need to be able to go into other messages that suggest the same drugs. Because I can go a day later, because one of the questions I asked
I'm
was,
just saying the doctor's gone. I'm just saying the message you try to convey to the jury is, you want to listen to me or
Okay. Right there.
I'm listening to you.
Okay, right there. Some of you are saying this is her husband, Ed Joyner. So when the judge is talking to an attorney, you don't have another attorney going and whispering in the attorney's ear who's supposed to be listening to the court. So right there is another bad move by the defense team. Unbelievable.
what did I just say?
You said, do I need to let the jury know?
No, I said the doctor's gone.
I heard that part too. But if you would remember, what I said was, if she told you she did mushrooms, would that make a difference?
Right,
I have a
that's
text.
not what I'm dealing with. I'm dealing with the question that you used this text message from what you said was Miss Benning, and now that's not true.
You sustained their objection to this text.
You went and asked the question a different way the second time,
And the
and
question,
they didn't object.
the question I asked was,
She's putting a spin on a lot of stuff here.
if she told you she did mushrooms, would that make a
And
difference?
the final question, we can replay it.
We can't, and I
It was a final question that the prosecution was flat-footed and they didn't address as not having a valid basis.
also
The final
asked,
question you asked was this same thing.
it was, but the drugs
And
are
she
still
said,
the
no,
same.
that, I didn't know that.
Yeah, we can clear it up and I can talk about the same drugs in
I'm
a
not
different
dealing with
text.
the others and whatever the witnesses. I'm dealing with, were you wrong on who generated this text?
I
Admit it.
was, but that text did not come into evidence. The question was,
Your question included the text.
Okay. Listen to this. Let me back this up.
She
still
said,
the
no,
same.
that, I didn't know that.
Yeah, we can clear it up and I can talk about the same drugs in
I'm
a
not
different
dealing with
text.
the others and whatever the witnesses. I'm dealing
You just want to gloss over the fact you asked a question that didn't have a valid basis to ask, a good faith basis to ask, by just bringing up all this other drug stuff, right? No, that's you can't get us out slick the jury like that.
with, were you wrong on who generated this text?
I was, but that text did not come into evidence. The question was,
Your question included the text.
no, it did not. Not what was in front of the question this witness was able to answer did not deal
The
with the
question
text.
they objected to and it was sustained did not come in. Then your final question after the mushrooms and everything else was, if you knew that she was taking Adderall to the point of shutting down her body, would that been contrary to her history? She answered, yes. They didn't object.
They didn't object. There you go. Prosecution, you need to up your game. You're flat-footed here, and you should know exactly what reference that is. Not be, look at, none of them are looking anything up on their computers of the middle attorney. Look at his screen is black. The one on the far end just has a screensaver on there. Maybe the attorney on the right, I think her name's Jan. Maybe she's looking something up, but they should have a hard copy of this, be able to show the judge. And she did earlier, but they're just not adequately prepared as trial attorneys. I can tell you that.
So the jury heard all that.
And they can bring the doctor back and say something different.
She's gone.
Well, she can come back if she wants to impeach that. She can.
And you said it didn't.
So if the prosecution has to impeach something that wasn't in good faith basis asked by the defense, that's not how it works.
Get out. Why was she saying impeach?
Because you're saying it did, and I'm not
It
gonna.
did.
Well, then she
I'm
can
gonna
do
bring
what
the
she
jury
needs to do.
down.
Your Honor, I don't
Tell
wanna
them
argue with the
that
court.
questions are not evidence, which I told them from the get-go,
That's right.
but that the question you asked, generated from a text from Ms. Benning, was not from Ms. Benning.
The question I asked had to do with the drugs Ms. Benning was doing, and there's a plethora of
You weren't
evidence.
asked about that, and I'm not getting into it.
Okay, well, that's what, if she goes
If
into
you
that,
think you want
I mean, you have to have a valid good faith basis to ask a question. You just can't have a plethora of drug usage information and then start attributing stuff that somebody else said to the person that was murdered. Okay, you cannot do that.
a question now, who you know is Ms. Jackson, and we have a jury out. Do you think it's relevant that this text comes in to impeach Ms. Jackson about her reliability?
no, I don't.
Oh, then let the jury step in.
All right. Judge is letting her off easy, actually. I mean, I'm just telling you, a lot of the judges, they would like rip your head off. You tried pulling a stunt like that, even if it was an innocent mistake. You don't know your case well. You should get chewed out. You should get chewed out. Judge is kicked off, but he's not doing much about it. He's going to correct the record, but he's not putting this attorney in her place. I'll tell you that, in my opinion.
or not. Ladies and gentlemen of the jury, let me give you this piece of information. One, and this deals with Dr. Malala's
No,
testimony.
I'm gonna object to this
Wow, look
on
at
the
that.
record in regards to.
All right, let the attorney step up.
You just blurt out an objection to the judge. You know he's going to start talking to the jury, so you just openly stand up and just blurt out and start talking to the judge. Excuse me, you know, there's not even an excuse me, Your Honor. Let's go back. Is there an excuse me, Your Honor?
And this deals with Dr. Malala's
No,
testimony.
I'm gonna object to this on the record
I didn't hear that. If there wasn't, I didn't hear
in
it.
regards to.
All right, let the attorney step up.
I mean, she's basically in this judge's face, and he's not doing much about it. Just I can tell you the when I was, because these attorneys are from out of state, when I was went to a different county up in North Texas, and I was on a case that was not my case. I was trying to fix something else that some other attorneys had messed up, and the opposing counsel interrupted me on something, and then when I was trying to clarify something, I unknowingly interrupted them for a split second. The judge just he started yelling at me really loud and saying, "I've had people interrupting each other all day long," and she's looking at me and just screaming at me. And I'm like, whoa, what's going on here? I've never seen a judge act that way. So for something like this, not having a good faith basis on a murder case, you're asking a question and taking all this time and all this fracas, and just people make mistakes. So unbelievable. Yeah.
So just so the court reporter understands what we were talking about at the bench conference, you, Ms. Hollins, are now saying that you didn't say it was okay for the court to instruct the jury that question coming from Ms. Bennings, a text from Ms. Bennings, was wrong.
What I thought the court was.
Did you say that or not?
Judge, I cannot.
But
I
you
cannot
play back
respond
the
and you cut me
video.
off
Look at-
every time that I'm trying to protect.
I said,
This is unbelievable, folks, that an attorney will do this and get away with it. Look at this. He's talking to the court reporter, and she just interrupts him again.
What I thought the court was.
did you say that or not?
Judge, I cannot.
But
I
you
cannot
play back.
It calls for a yes or no answer, and she's, again, trying to go off on tangents. Now, you can tell he's addressing the court reporter.
Back the
cut me
video.
off every time that I'm trying to protect.
I said, I'm gonna bring the jury in and instruct them that questions aren't evidence, and that
That's
your
what we
question
Look at,
about to the doctor.
she's still over talking the judge, interrupting the judge, and he's just trying to talk through it, but he's not calling her out on it. Anybody that wants to be attorney or is in law school or wants to be a trial lawyer, this is exactly how you do not conduct yourself, okay? Interrupting a judge, screwing up the case, and then you're going to go in and act this way and even do this in front of a jury. I can tell you, most judges would never let this happen and just continually just have this kind of patience and let her get away with it.
Malala about Miss Benning generating a text that she was starting to feel like her body was shutting down did not come from Miss Benning. You now agree to that, right? You agree the text did come from Miss Benning,
I do agree that the text would come.
but you're now saying you didn't say that was okay.
No, what I thought the court was saying was
Sure.
that you were going to instruct.
If I'm the judge, I'm saying, you know what? That's what I'm doing. I don't care. You can note your objection, put it on the record, but that's what I'm telling the jury. Okay. I run this courtroom. Okay. You didn't have a good faith basis. That's what I should be telling the jury. There was not a good faith basis for the defense to ask that question. It was actually a different person. And so therefore, to disregard the last answer and question posed by the defense, which happened to be, and then restate it, have the court reporter restate it back for the record. So the jury completely gets it. Because think about it. They had over an hour break now. They're just brought back in, and now she's just blurting out objections again. So, I mean, this looks like a hot mess courtroom.
The jury that what the lawyers say is not evidence. I don't have a problem with that. But if you want to comment on exact evidence, the court can't comment on evidence. The proper way for the DAs
So she's now telling the judge what he can and cannot do? Really?
to impeach me is to bring that witness back in and
Impeach you? Is that what she said?
on exact evidence. The court can't comment on evidence. The proper way for the
He's not commenting on evidence per se. He's commenting on, it's actually a ethical requirement for the attorneys to have a good faith basis. It's an ethical requirement. So it's just not a evidentiary requirement, a court requirement of rules of procedure. You actually have to have a good faith basis. So that's what the judge wants to do, is preserve the integrity of the process.
DAs to impeach me is to bring that witness back in and then ask that particular question in regards to this exhibit. That is the proper way. Then at that time, I have a right to come back and ask about those very same drugs so that the jury doesn't believe that I'm misleading them. The way that the court wants to do it, it makes the jury believe I'm misleading them
You did.
about the drugs.
Because you misunderstood the
You're
text.
right, but the court sustained the state's objection.
Not the third time.
The third time, if my
You're-
question is wrong, the proper thing for them to do is to bring that
But
witness
that
back.
message got to the jury. So how would I explain to the jury what question or what information we're talking about?
Your Honor, that's not.
I don't know why the judge needs to ask this question. It's really easy how to fix it. So I don't know. This judge seems tough on one hand. On the other hand, he's just like letting stuff slide. Yeah. Oh, yeah. Here, Lee, are you in Tennessee? Cannot imagine even being a member of the Tennessee bar and lecturing a veteran Tennessee judge on what's allowed and what's not. Yeah, I mean, she's just pushing him around the courtroom and he's letting it happen.
For you to do, it's for the state to do.
How would you're saying it's okay for me to bring the jury in and instruct them that what the attorneys say is not evidence?
That's correct.
About what?
That's for the jury, for them to come back and decide if the court comments.
You didn't have a good faith basis to ask the question, whether it was intentional, a slick move, or it was innocent. Let's just say it was an innocent move. You and your team or it was an oversight, inadvertent oversight. The judge needs to clarify the record on that and let the jury not be tricked into believing that that was a statement from an email from Jade. So this needs to be cleaned up.
On direct evidence, it is improper. And the court knows
There was no evidence of your
Court knows
question.
that. So she's basically saying the judge, you're trying to do something you know is unbecoming, unethical, or unjudicious.
the jury, for them to come back and decide if the court comments on direct evidence, it is improper. And the court knows
There was no evidence of
And the court knows that. So you're basically insulting the court right there. I just can't believe it that somebody can get away with it.
your question.
Then why are we talking to the jury if there's no evidence?
Because you brought it up and misunderstood what your staff gave you.
So that means that the state has a right to bring that witness back up. That is the way that is handled. It's not for the court to then impeach me.
So that witness doesn't know anything about the text messages that you brought into question. So how is that fixing it by recalling that witness? Huh? That witness doesn't know the truth of whether that's a good faith basis or not. So that's like a ridiculous comment to make.
That's not the way that
Is
they
the
do
doctor
it.
still around?
That's
No,
not
Your
the
Honor,
way.
but she
Okay, you know
keeps
what?
talking
That's
about
not the way courts in America handle it. Period. Okay, so that's not the way. So she's trying to basically intimidate the judge and make it sound like, Judge, don't you know? Don't you have a clue to the way that really works in courtrooms in America?
Impeaching her, she's
I got
supposed to
it.
be ethical, follow the rules, and not lie to the witnesses.
There you go. Gosh, she finally stood up and made a comment. She said, you have a duty to ask questions, legitimate questions of witnesses, otherwise it's unethical. That's what I said earlier. So she finally said it. But look, what does the judge do?
Okay, so
She wasn't unethical, she was wrong about who sent the text.
Okay, she was wrong. So, okay, judge, did she have a good faith basis? Why don't you address the sloppiness at a minimum, if not outright deception by the defense team? It's one or the other, and call them out on it and hold their feet to the fire. But you know what? If you're automatically saying it was an accident, okay, if it's an accident, then they didn't intend to. At least fix it with the jury.
Maybe that's the last time that'll happen.
Oh, you're right, Your Honor.
All right, let the jury step back there.
Thanks, California Dreamin'. Appreciate that. Yeah, the other defense lawyers on the defense team know they're looking like fools, I think. Let's speed this up. Okay, let's see how this was handled.
Is that questions asked by the attorneys, as I told you yesterday, questions, arguments are not evidence.
Okay, that's questions asked are not evidence, but they have to have a good faith basis to ask the question, and he's not even addressing that. That's universal in all courts in America. Any court in America, you have to have a good faith base for asking it. Like I said, you just can't sit there and say, well, Dr. Malloy, are you aware she was smoking crack and getting drunk every night and in a coma from taking cocaine 2 nights earlier and heroin the 2 nights before that? I mean, you just can't make up smear bomb type of cross-examination questions. So the judge is not even, I think, handling this the right way at all.
Unless it's adopted by the witness, as I said yesterday. There were questions during Dr. Layla's testimony about a text generated from Ms. Benning that's now acknowledged that text was not from Ms. Benning. So just disregard that information.
Okay, you should say what the text is, clarify it was from a different witness, and if you want to say the name of it, fine. So
step up, please.
Do you swear the testimony you're about to give to the truth, so help you God?
I do.
okay, here we have the next witness being Keontae Jones.
Sir, could you please tell us your name and spell your first?
This guy is now in his last year of dental school there in the Tennessee, Nashville area. And let's go right to the part where it's really damning for the defense. Here we go. I'm going to start it out.
And Ms. Jackson as panic. You use that word. Their voices, the tenor of their voices.
Mm-hmm.
Was there a difference between the two types of panic?
There was a difference. Miss Jackson's, like as I stated, was more so of like a frantic, worried panic, and I don't know what language I'm allowed to use in here, but
For all adults.
Mr. Taylor's was more so of like a no shit, I just effed up type of panic.
That's a type of panic. So this guy is saying it was like, oh crap, I effed up. So you know what that means? It means exactly what I thought was probably the case, which is he didn't intend to kill Jade. He just intended to have the baby aborted. All right. So
Those are my questions.
Any other questions?
Sure. Mr.
okay, this
Mr. Jones,
Yes, sir.
okay, Goddess, you seem to be very very talkative here on this channel, and you're thinking all this is just nothing but a hearsay case, really? Well, guess what? One of the things I can tell is hearsay is admissible, admission of a party opponent. So anything the defense says is admissible in the trial. So if you want to say everybody's lying, you want to stick with the defense, that's fine. I'm here to get to the bottom of things. So obviously you're on a campaign for the defense, so that's fine. That's fine.
that description that you just gave while the state was on redirect, oh shit, I fucked up panic. Have you ever stated that before at any time to anyone?
Yes.
Did you state that to the investigator when he spoke to you on April 30th?
I don't know if that question was even asked in that investigative.
Okay. Well, Goddess, you don't know how to follow evidence. You don't have any law background. You've never tried a case, prosecute a case, or defend a case. So if you think there's no proper evidence, then I guess you'll be very surprised then when this guy is convicted. That's my prediction, what I've seen so far. And I've not even seen all the case yet, all the case file. But there's enough indicators of guilt that I'm making an early prediction right now.
Conversation.
Do you not remember?
As I already stated, that was about 2.5 years ago, so no, I don't recall.
And would, if given the opportunity to review a transcript of that conversation, would that refresh your memory and aid your testimony here today?
I think it would.
This is the weird part here where he never said it before, so he's trying to make it
Can
look
I
like,
say where would you like me to be reading, or should I read the whole thing?
like this guy's lying and making it up. But the thing is, if you don't ask a certain right question of a witness, they may not volunteer that information. They don't know how important and critical it might be.
Take a moment, read all of it.
So he sits there like 10 minutes reading over this whole thing. Let's jump ahead.
I mean, we would be here a while if I read all of it.
It's worth it. Please take your time, familiarize yourself, please.
Okay.
I'm jumping ahead here. I've never seen this before, where a witness is allowed to read through an entire statement that they previously gave for like 10 minutes.
The description you gave that Mr. Taylor was, oh, I fucked up panic. Have you ever given that statement to anyone at any time?
Yes.
When?
When I met with the DA.
When was that?
First time I probably gave that testimony was back in February.
Of this year?
Yes.
Okay. And did you talk to Detective Reese on February 28th of 2023 by phone?
I don't know who Detective Reese is.
So if he said he spoke to you, you don't recall that?
Is that who this person is?
No, sir.
I don't know who Detective Reese is.
Thank you. No further questions.
Any other questions? Yes. you. Mr. Jones?
Hey, jumping ahead here. That's my take on that is that's really damning. So anything you see about the defendant acting nervous or frantic or scared, whatever it is, I think it is that he's panicking because this thing is blown out of control. He just wanted to give some cocaine to cause a miscarriage, not cause the death of the mother. So I think that's the takeaway. But you're criminally responsible for both being a murder, and that's what the evidence is looking like. That's what I predict the jury's going to come back with here. This is the other paramedic. And let's see, I'm going to go to the cross-examination. Let's go to the cross-examination here at 6:30.
So that's the only thing he told us.
Okay. And you don't know whether he just doesn't know a lot, do you?
We don't know. He couldn't answer anything.
Sure. Okay. But he did tell you that she was pregnant.
Mm-hmm.
Right? Okay. If I could see Exhibit 5, I think the most recently introduced exhibit.
A report?
The report, yes.
You want her to see it?
No, I'd like to see it. I think it'd be good. I'm unfortunately, I apologize. I don't have a very fancy presentation with little things snipped out, so we'll kind of have to do this the old-fashioned way. Got to hit a button here.
Yeah.
Let's see here. I want to talk for a second about the timeline of this call. Let me get to this page. Okay. My goodness. Okay. This portion of the report right here, do you recognize that?
I do.
Is it accurate to say this provides information about when various things occurred during the call?
Yes.
So the very first entry, what does PSAP stand for?
I honestly have no idea. Maybe what time the call came in. I'm not sure. We don't do anything with the times until unit dispatched.
So it's the very first entry in this report, right?
Mm-hmm.
And 2138, I'm so terrible with military time, but what's 2138?
9:38 p.m.
9:38. So potentially that's when the call was initially made to 911, right?
Correct.
The next entry is dispatch notified 2140. That's 2 minutes later, right?
Correct.
And is that the time between the call was made and they're finally dispatching you guys, telling dispatch we need somebody to get out on the road?
Unit dispatched is what time they contact us.
Okay, it's the same time between dispatch notified and unit dispatch, 2140 and 57 seconds.
Correct.
So almost identical. That's you guys getting up being told you need to get out on the road.
Correct.
And we don't know why there's a 2 minute delay.
All right, so I'm going to
up at the very top there.
No.
You are en route 941.
Correct.
We're going to go ahead and jump to Sergeant Pfeiffer, Metro Police Department there. I want to show the video from his body cam.
You find from your listening to the audio, seeing on the visual, that there's something different between what you hear and what's related in the transcript. You have to rely on what you think was said. Okay?
We need Mike.
Okay.
Hey, ma'am. What's happening today?
I'm
So I was like, well,
They're fine. What's happening today?
So, my girlfriend, she's obviously in emergency room or whatever.
Yeah, I got that.
Yeah, I was, last one, we were together, had a date night.
Where were you? Where? Where?
At her place.
At her place. Okay. Where's that?
It's off, Lebanon Pike. It's a new build. She just moved there.
Do you know the address?
No, I don't know the exact address. I just know I know how to get there. It's real easy to get there. And I know it's
Well, what electronic means did you use to get there? So not off the top of your head. Yeah, I have it right here. So he's just trying to play dumb, it looks like.
case when I get to Burger King, I know it's right there. I just turn left. But it's a new build. They're still not even finished with all the buildings there. But her building's but yeah, she's apartment 1 condo, apartment 107.
So what's what happened today?
So went over there. She's like, hey, got this thing planned for us. Date night, 7 o'clock. So at 7 o'clock, go ahead. She cooked dinner. She had this canvases for us to paint, and all that stuff. And then get there, do all that. She made a lot of food, so one of her friends.
He sounds like he's nervous about something he did. That's the vibe I'm getting. What do y'all think? So, does he sound like he's more concerned about what he's telling the cops, or more concerned about them getting Jade and the baby saved? Huh? Which is it? It doesn't sound like he's as concerned with them surviving it as he is. What do I got to say? What do I got to say here? Because I'm looking guilty.
Came by with her, I think boyfriend or friend or whatever. They picked up some food, stuck around for maybe about 5 minutes of the house, and then it's just us hanging out.
Well, I will say the mask thing. It was required. It would have been required there at Vanderbilt Hospital. So if you want to go in and out of the hospital, he's standing outside right there. But you're required to have that on. But yeah, he couldn't take it off right now, being outside the hospital, is what I recall.
And all that, she started not to feel well. It's kind of all the blood. She wasn't feeling very good. And I seen her, she was like throwing up and shaking. So then I called my dad and I was like, hey, I don't know what to do. And he was like, call 911. Called 911. Immediately, I got called 911. They kind of walked me through what to do, like, turn on the side, walk with them out, and all that stuff.
Had she been drinking at all tonight or anything?
Not the alcohol. I didn't have alcohol or anything like that. There's no alcohol.
Were you guys arguing or anything like that?
No, not at all.
No arguing.
We don't do that. We haven't.
I'm just asking.
Yeah, no, I understand, but no.
So do you know what, like, was it some GA or you know?
I don't know. The people I talked to on 911, they just told me that they thought it was just like she's having a reaction or something. They were asking me a lot of medical questions, but I didn't really know. They were asking me to check out the pain, and stuff.
You know what how he's acting like? He's acting like, oh crap, this is out of control. I may have killed both of them now. That's what it looks like to me. That's the vibe I'm getting. He doesn't say, the thing is, how does she get something put in her drink? You're telling me she's going to put in some cocaine, a massive load of cocaine in her drink, and not offer to share it with him, and he's not going to know about it? This makes no sense. No sense at all. And then she's going to do it while she's having a baby. She's never had cocaine from what we've seen in her history. and now she's going to take a massive mega dose of cocaine, or any amount of cocaine for that matter. It makes no sense whatsoever.
It's all that was spend, here or whatever. You still live at 1903 Ashton Ave? Yes, sir. Overall, there's no like violence or anything, threat violence, stuff like that. Oh, no. It's just all kind of fall kind of thing. Yeah. She just had some type of, yeah, absolutely.
All right, you can pass those transcripts back down this way.
Okay, so that's I think when you look at demeanor, like I said, it's very critical, especially on a murder case. And you got this video footage of the defendant, so he knows he's got to cooperate. He's not going to be stupid enough to say, nope, I invoke, I'm not going to talk to y'all. So he's got to put the facts out there that, hey, she had something to eat, some kind of allergic reaction, and where they actually said it was poisoning, that's not something he's volunteering. And if he's going to give her spike her drink and then he realizes it's gone south, well, is he going to do the right thing and say, look, I gave her some cocaine, I thought it was going to give her miscarriage, but I didn't know it was that much, right? And the thing is, what the defense said is that this guy is not using legal drugs. So if he's not using legal drugs, somebody like him would not know how much to put in there and how much is too much. So if you're a normal user of cocaine and you have familiarity with it, I certainly don't have that experience. You would know how much it takes to get somebody to have some kind of bad side effects short of killing them, I would imagine. So anyway, I'm going to go ahead. This is pretty much the wrap up from day one. So I'm going to take a break and then jump back on, and I'll do another announcement. So it'll be within the next hour. I'll jump on and we'll do another follow up for some of the other trial coverage. So stay tuned. I'll be back here in a little bit. Thank you.